Ripple was deeply troubled by SEC when the U.S. Securities and Exchange Commission advanced its position by making a request for remedies and entering a final judgment. The ongoing legal conflict between Ripple Labs and the government reached a new level of intensity. This motion demands a $2 billion fine against Ripple for a series of comments made on X, formerly known as Twitter. XRP advocate Fred Rispoli has provided an in-depth examination of the SEC's motion. Rispoli's analysis offers a unique insight into the current situation, outlining the various strategies and possible outcomes. He claims that the SEC has publicly announced its move for judgment. In short, the SEC is following the plan that I laid out 2 months ago. This statement emphasizes the seriousness of the situation for Ripple while also referencing the predictability of the steps taken by the SEC. In addition, Rispoli shed some light on the way Ripple's business methods were described by the U.S. Securities and Exchange Commission. Despite the increasing legal scrutiny, Rispoli has continued to exploit XRP sales as the company's major source of revenue, particularly with his detailed XE assertions. Despite ongoing litigation, the Financial Discovery Aid shows that these purchases are Ripple's main source of revenue. The company has signed 180 contracts with institutional purchasers since the beginning of the XRP lawsuit in December 2020. A lawyer who supports XRP has predicted 2 different outcomes. Another crucial part of the Rispoli analysis is classifying the on-demand liquidity. An important factor that could affect Ripple's operating flexibility is the legal evaluation of whether these transactions constitute unlawful sales or are allowed according to the law. While a ruling in favor of Ripple on the amount owed is probable, the company may face restrictions on what it can do going forward, prompting an appeal to a higher court. In a brief published by the U.S. Securities and Exchange Commission, a different perspective is offered regarding the fines and penalties that should be imposed on the blockchain company Ripple. This perspective differs from the one that the company's executives are advocating in a document that was submitted to the U.S. District Court for the Southern District of New York on March 25. The attorneys representing the SEC proposed that Ripple should pay a total of approximately $11.9 billion. The regulator determined that the fines and penalties were justified due to Ripple's willful disobedience, which included keeping selling XRP despite receiving legal warnings. The filing was in accordance with what Ripple Chief Legal Officer Stuart Alderoty announced would be made public in a post published on March 25, which was about $2 billion in fines and penalties. Ripple is in a good position to pay a substantial civil penalty, which is justified for 2 reasons. First, a civil penalty should not be just the cost of doing business for a securities law violator, as the Second Circuit has ruled, and second, the need for deterrence is clear given Ripple's enormous amount of unregistered sales of XRP over the last 3 years, as the author writes. It was alleged by Alderoty that the SEC was planning to punish and intimidate Ripple. The company was expected to respond to the proposed judgment in April, according to the order. The only way to make Ripple reconsider is to impose a heavy fine and restore the ill-gotten riches it made from its crimes. To proceed cautiously with its lawsuit against Ripple CEO Brad Garlinghouse and co-founder Chris Larsen, Ripple resolves the amateur error that happened on the XRP ledger a few years ago. The corporation has acquired $1.3 billion in unregistered securities by selling XRP coins, according to the Securities and Exchange Commission. Judge Annalisa Torres's ruling in July 2023 that XRP was not a security regarding programmatic sales on digital asset exchanges followed the filing of the case in December 2020. David Schwartz, the chief technologist at Ripple Labs, recently grabbed headlines and stirred the cryptocurrency industry with his comment on the difficulty of avoiding XRP sales due to tax levies. Schwartz's remarks were well received. He highlighted the tax responsibilities associated with cryptocurrency holdings and pointed out that the Ripple CEO and his staff will almost certainly have to sell some XRP to cover their tax bills. As an example of his thesis, Schwartz said that corporate insiders like himself might have to sell XRP to pay our taxes, which is a change of direction from his previous viewpoint, which held that owners of digital assets could sell whenever they wanted. For instance, Schwartz demonstrated that selling a significant portion of a 1 million XRP bonus would be necessary to meet the tax obligations associated with the incentive,